Hello everyone. I hope you all are doing good in this quarantine period. You are all are staying home and you all are staying safe. So today we are here with the second lecture on our series Jurisprudence and Legal Theory. In our previous video we covered origin of law, what law means, what is a legal system, what are the basis of a legal system, the definition of jurisprudence, etc., and major legal systems in the world. There are three major legal systems we talked about: Romano Germanic, common law, and socialist law in our previous lecture. So, let's move forward to this lecture in which we will be talking about Indian legal system. So, with our lecture 2, we are entering into Indian legal system. Since we are talking about Indian context, this topic is going to be a large topic because all the aspects of Indian law would be covered under this title. So, let's begin with the video. First of all, let's quickly summarize the three legal systems. Romano-Germanic family talks about civil laws, that the matter should be resolved between two parties, and it demanded codification of laws. Another one is common law family, which predominantly brang the judicial system, the judges system in the legal context, and it didn't demand codification. Last one is socialist law, which talks about popular will and originated in USSR. It is a part of Romano-Germanic family, as it has taken a lot of features from the Romano-Germanic family itself. So it is interesting to note that all the legal system across the world in different countries either follow any one of these three families, or the laws in the different countries are derived from the combination of laws from all three categories. Majorly they are followed across the world, but there are some countries, there are some regions where these laws are followed, but they are followed in a smaller extent. So other legal systems are far eastern countries like China, Japan, etc. They follow the laws made out of their own ancient civilization. Also in black Africa and in black Africa, the laws that are being followed, they believe in restoration of harmony among the people more than the respect of laws, so they have their own separate laws. It is important to note that all the religious laws, the customary laws like Muslim law, the Jewish law, the Persian law, the Hindu law, they pay great emphasis on their own customs. Therefore, there are legal systems and laws which are not following the three major legal systems or the three major legal families, that is Romano Germanic, common law, and socialist law family. So this was all about the three legal systems. In my previous video I told you about the three systems, and I asked you to deduce the similarities and difference, that is comparison and contrast between these three systems. I hope you all have found that. So now let's move to uh, our Indian legal system, but before that let's quickly study type of laws and statutes. So law are basically of two types: criminal and civil. Criminal, as the name itself is suggesting, it deals with crime are the wrongs that are committed against a society at large or public at large. So crimes like murder, like theft, like kidnapping, which are common and affect societies in a similar way, like they are doing, obviously the victim will be suffering more, but these kind of crimes are threats to a society, so they are like dealt in criminal laws. So the codes under this law, the criminal laws are Indian Penal Code, CRPC, Evidence Act, etc. These offenses under criminal law have their specific elements which make them criminal. Okay, then next is civil law. Civil law is a part which deals with private affairs of individual. Like suppose A and B enters into contract and B cannot fulfill the conditions of a contract, so the matter will fall under the civil category. Between two individuals, it is only affecting the mindset of two individuals, not the society at large. So it is civil law. For example, the law of contracts, the law of torts, property law, etc. Now there are two more categories. One is substantive laws and other is procedural laws. So what are substantive laws? Substantive laws are the set of laws that governs the behavior. Like they allot duties and rights to the citizens when it comes to civil law, that you have to that a citizen has to abide by all these duties and give the crime, what is a crime and what is its punishment in criminal field. So for example, let's talk about Indian Penal Code. Like section 300 talks about murder and 302 talks about its punishment. So 300 is murder. Murder is a crime, and what is its punishment? Its punishment is talked about in section 302. But how it will be seen that a murder has occurred, how the inquiry will go on, who will do the inquiry, that is the procedure. And such laws which define the procedure are called procedural laws, and these are given in the procedural laws, which are remedial laws, or they are also called adjective laws, which gives the idea of how laws are proceeded, how an inquiry is proceeded or a suit is proceeded in the court of law. For example, CRPC, the Code of Criminal Procedure, Code of Civil Procedure, they are the procedural laws. Now, there is one question that I want to ask you. So, the question of today's video is Indian Evidence Act 1872, it is a procedural law or a substantive law? You have to tell me in the comment box below. Alright, so you have to tell me Indian Evidence Act 1872, it is a procedural law or a substantive law. I am waiting for your comment in the comment box, and also give reason why did you choose the answer to be either of procedural or substantive laws. Let's move forward to Indian legal system. Now, since in the earlier part of this video I have told you that all the systems across the world follow the three major families, so Indian legal system has also derived its components from these families, especially common law family. Customary and religious laws are the second source of Indian legal system, and third one is Romano-Germanic family. Why common law family? I think we all are aware of the fact that Britishers have ruled over India for a very long time. From 1773, the East India Company put their setup in India, and till from 1773 to 1857 there was the rule of East India Company, and after the revolt of 1857, Crown made its rule in India till India got independence. So the first law commission was set up under Lord Macaulay in 1854. Hence, Britishers have impacted a lot in our legal system. Therefore, a lot of components are derived from common law family. Another one is customary practices. So, India is a country of religions. A lot of religions reside here, so we cannot ignore the practices, the culture of all these religions. Therefore, these religious and customary practices are an essential source of Indian legal system. Third is there are salient features we have taken from Romano-Germanic family. Let's quickly see what is taken from where and how much. So features of Indian legal system we have adapted from English law are the court system, like the judges deciding the matter in the court in the eye of law is taken from English law. Rule of law says that everyone is equally liable, equally important, or let's say it in simple words, equal in the eyes of law. Third is adjudication on the basis of precedents. So if a matter comes in the court which is similar to a matter that has been decided earlier, the earlier case, the earlier decision will be referred as the precedent for this case. Adversarial disputes. So there are two systems of resolving disputes. One is adversarial system, another is inquisitorial system. So India follows adversarial system. Now let me quickly tell you what are these two systems. In adversarial system, the judge decides the matter on the basis of facts, proofs, evidence presented by the lawyers or the advocates or the legal personnel of both the sides. But in inquisitorial system, a judge, he inquires the victims, the proofs, etc., in order to investigate the matter. So in adversarial system, the judge relies upon the legal personnel attending the case for both the parties. India follows adversarial system. Next point is independence of judiciary. Judiciary is independent from the other two streams related to law, that is executive and legislation. Justice, equity and good conscience, they are the features embedded in our preamble as well, that there should be good faith when a law is made or is being followed or is being interpreted. Another one is judicial review. Judicial review is the property where a decision which is earlier made in the court of law can be challenged again, whether it was a winning case or a losing case, it can be challenged again in the eye of law. So these are some features, predominant features we have taken from the British law, the English law, the common law, whatever we can say. It can be also said that Indian law resembles to British law at a large extent. Next is adaptations from customary law. The Hindu law, for example, the Hindu Marriage Act according to Hindu customs, the Hindu Succession Act according to Daya Bhaga and Mitakshara schools, they have been embedded in the legal system. The Muslim law based on the culture and practices followed by Muslims, Jewish and Christian personal laws. Also tribals follow their own laws until they follow their custom as laws until an official gazette is released by the government for them. So here we can see that customary laws or religious laws are second major source that constitute Indian legal system. Third one is adaptation from jus civile, or we can say Romano-Germanic family. So Indian constitution is codified. Hence the feature codification of laws, statutes, constitution is taken from jus civile. Substantive civil laws, for example, we have Indian Contract Act, etc. These substantive civil laws are taken from jus civile. And Uniform Civil Code, Article 44A under DPSP of Indian Constitution, it is an adaptation we have taken from the socialist law. So we can say that Indian legal system is a blend of all the legal systems along with customary practices, predominantly led by the common law family. Next, let's quickly talk about the three major parts of Indian legal system, or we can say the Indian system. So every legal system has three main parts: the one who makes the law, other who executes the law, and the one who makes sure that laws are interpreted in the right way and they are being followed and they are being protected. So in India we have three layers with separated powers, not layers, three divisions: the legislation, which is parliament and state assemblies that make the laws; the president, the governor, which execute the laws, they are called executives; and the judiciary, which interpret the law, protect the law and make sure that law is being followed. So since we're talking about legal system, let's have a look at judiciary in India. So hierarchy of courts are like: a matter first go to magistrates. If someone some party to the matter is not satisfied based on certain conditions, he or she can apply in the district courts. Again, if he is not satisfied, the matter can be brought forward in the high court. And still, if they want to proceed further, the apex court, that is Supreme Court of India, is the option. By judicial review, special leave petitions, the earlier etc. provisions, the earlier made decisions can also be challenged in the apex court. So, how a matter is brought in before these courts? What happens when a matter comes in the eye of court? The tribunals and forums, how rule of law works in India, Lok Adalat, legal services, the Advocates Act in India, all these topics we will be covering in our further videos. Till then, the question of the video was, is Indian Evidence Act a procedural law or a substantive law? You have to answer it in the comment box below. And for any other information, suggestion, queries, please feel free to contact us at legaldarshana@gmail.com. Thank you for watching this video. Stay tuned with us and don't forget to like, share and subscribe. Thank you.